Hi, I'm Patrick Hanrahan, a Legal Practitioner Director at JHK Legal, and today I'm here to talk to you about the importance of testamentary trusts. Whether you've just bought your first property or other major assets, or perhaps you're the director or owner of a business. Maybe you've just landed your first full-time job. Or you might be about to get married. Estate planning is relevant to everyone in many different situations. Whilst most know what a will is, often what is not known is whether a testamentary trust should be used within the will for the benefit of the beneficiaries. Let's start with what a testamentary trust is. A testamentary trust is a trust that is set up within the will. When a will doesn't contain a testamentary trust, assets are simply gifted through the will to beneficiaries. However, with a testamentary trust, the assets can be held within the trust for an extended period of time. With a testamentary trust in play, there's far more flexibility in distributing the assets of the deceased to the beneficiaries. Firstly, the assets can be protected in the event that any of the beneficiaries was unfortunately to be made bankrupt. Further, in the event that a beneficiary goes through a relationship breakdown, then the assets can be prevented for distribution to the beneficiary whilst the beneficiary resolves the issues. There can also be tax benefits. Assets don't have to be sold immediately, thereby triggering capital gains, but can be held in trust, and the revenue derived from those assets can then be distributed to beneficiaries in the most tax-effective manner. If beneficiaries are quite young or financially irresponsible, then a testamentary trust can provide flexibility for the timing of when assets are released to the beneficiaries under the will. So let's look at an example where a testamentary trust can be really effective. Let's assume that a deceased owned an investment property at the time of passing away. The deceased had 4 children, all of responsible age, who would receive the benefit of the estate in equal shares. Without a testamentary trust, on probate of the will, the executor would be tasked with the job of immediately arranging the sale of the investment property, payment of the debts of the estate, and then the distribution to the 4 children in equal shares with the proceeds. Well, what if the property market wasn't great at the point in time of selling the property? Or perhaps one of the children had become bankrupt? Or the property investment was producing good yields through rental income? If a testamentary trust was set up in this circumstance, we can deal with all of the above factors. The investment property is then held on trust for the beneficiaries under the terms of the trust. The trustee then has the discretion on when to actually sell the property. Also, the rental income could be distributed to beneficiaries in a lower tax bracket for tax minimisation. Now, often it's asked, how long can assets actually be held in the testamentary trust? And that's usually followed up with the question of, is there a risk that the trustee I have appointed could go against my wishes? Firstly, the assets can be held within the trust for a maximum amount of time that is listed within the trust. We call this the vesting date. This is normally, in most trusts, 80 years. However, the trustee is left with the discretion of the most appropriate time to realise the assets and proceed with distribution up until the vesting date. There is a risk that the trustee could act on what he or she believes is the most appropriate way, which might be different to the wishes of the beneficiaries. However, there are mechanisms that can be placed into the terms of the trust to allow the majority of beneficiaries to vote to change the trustee of the trust. There are other items of importance to consider when we're putting a testamentary trust into a will. People need to be careful about superannuation, as different circumstances will govern whether superannuation assets flow through the deceased estate or whether they are left to others outside the deceased estate. It's really important to choose your trustee carefully and appoint someone you believe will act in the best interests of the beneficiaries and adhere to your wishes. If you've got any questions about estate planning, or if you believe that a testamentary trust could be effective for your will, then please don't hesitate to give us a call at JHK Legal. We'd be more than happy to help.